The next case to come before the court is State of Ohio v. Christopher Blue. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know and I'll try to give you a warning of when you're moving into your rebuttal time. The arguments are being recorded, so please introduce yourselves, stay behind the podium, keep your voices up. You should not use the names of children, minors, or victims during your arguments. You can refer to those folks by initials or generic terms. We have read your briefs. We're ready to proceed when you are, and I would just ask appellant's counsel, would you like to reserve time?
Reserve 5 minutes, Your Honor.
Very well, then we are ready to go when you are.
Okay, thank you. Attorney James Reed here on behalf of the appellant Christopher Blue. As the court's aware, the appellant's brief had 5 assignments of error. The first 3 are pretty much the standard you find in every criminal case, criminal rule 29, manifest weight of the evidence and sufficiency of the evidence. And then the other one, 4th assignment, I think, was ineffective assistance to trial counsel, and then a cumulative effect argument. I'm going to focus on the first 3. And the argument for any one of those assignment of errors is basically the same, and it's pretty much summarized on page 19 and 20 of the brief I submitted. Somewhere along the line, I came across something that said there's 10 different types of evidence, and it listed them all out, and I wish I could remember all of them, but in this particular case, there's an awful lot of circumstantial evidence, and I understand that has the same weight as direct evidence. But on behalf of my client, Christopher Blue, I wanted to focus on page 19 and 20 of my brief because he had no burden of proof here. It was incumbent upon the state, obviously, to prove each and every element of the offense. And I listed them out here, and I'm just briefly going to go through them. I know you've read them and understand them, but I think when you take it as a whole, we get to the big issue in this case, which is this the exceptional case where the jury lost its way? And that's essentially the end argument I have to make in this case, because there was a second individual, Stephen Barclay, that was involved in this case. And for whatever reason, I don't know if he absconded, they found him and he absconded again. I don't know that he ever got charged with anything here. But this was a very short interaction. It started with a video clip almost an hour before from a home surveillance. And they saw 2 individuals walking, but then they had no other video evidence submitted that would have showed my client at the scene of the shooting at the time of the shooting. And there's no eyewitness that ever saw Mr. Blue inside the victim's vehicle. They didn't find his DNA evidence inside the vehicle. There was no eyewitness testimony that Mr. Blue interacted with the victim in this case. They examined Mr. Blue's clothing. They didn't find any of the victim's DNA on his clothing. Nobody ever saw Mr. Blue fire a weapon, let alone shoot the victim in this case. That his DNA was not on the shell casings recovered inside the victim's vehicle. That the firearm that they did find at a residence, I believe 750 Russell Avenue, had a mixture of DNA results, which obviously means more than one individual handled that firearm. But the BCI expert witnesses that testified, they were unable to state exactly where Mr. Blue's DNA was found on the weapon. They couldn't state that it was specifically found on the trigger or anywhere else on the firearm specifically. And then there was an issue that the gun that was found inside the residence was wrapped in clothing that was worn previously by Mr. Blue, so there could have been a transfer of DNA as a result of that. I believe the BCI expert acknowledged that because the gun was found, I think, 20 hours after it had been wrapped up in that clothing.
So what about all the text messages?
What's that?
The text messages.
that's about the most direct evidence in the case, but that covered, I think, a 3 or 4 minute period. It does indicate that they had communications between them, but it also isn't conclusive that that's completely separate than whatever happened after the text messages were sent.
Well, obviously it was a drug transaction, right?
Yeah, you know, it's one of these senseless, you know.
Well, it's tragic, it's horrible, but there was a drug transaction. And both the victim and the defendant, via their text messages, indicated that they were both there at the same location.
Within a 3 or 4 minute exchange in that general vicinity, correct. It doesn't put my guy inside the car, though.
No, but he says, I'm here, you know, and I'm here, you know, that kind of thing. Both of them were agreeing that they were here to conduct business.
And then the other individual, Stephen Barclay, who for whatever reason had a GPS device on, he was, after the fact, they determined he was specifically at that crime scene at that time that the shooting occurred. And then after that, he cuts off his GPS device and flees, which you could argue that's consciousness of guilt, but the officers that investigated the case apparently came to the conclusion that Mr. Blue was the shooter and not Mr. Barclay. We don't necessarily, well, we obviously don't agree with that, and as appellate counsel for Mr. Blue, I would say the evidence would presented was stronger that Mr. Barclay was probably the shooter. And going back to some of, you know, again, I don't want to.
And counsel, we're gonna find all of that evidence about Mr. Barclay in the record, which you're referencing?
Yeah,
No, is it in the record?
yeah, it's in the record.
Okay,
He did take the Fifth Amendment when, I think they called him outside the presence of the jury, if I remember right. But he took the Fifth Amendment and didn't testify in this matter. But I don't know, well, I guess I have a little more time. I wanted to go back, you know, one of the things that bothered me as an appellate counsel was they had some DNA evidence. They swabbed the inside of the vehicle and they decided either it was cost prohibitive or it wasn't going to be fruitful to submit that to BCI. And that pertained to whether my client, Mr. Blue, would have been in the front seat or the back seat of the car. It could have been potentially exculpatory to him, and it could have been Mr. Barclay's DNA found in there, but they didn't submit that to the BCI for examination. And they didn't do any fingerprint and DNA touch analysis on the cell phone found in the back seat of the car. Now, they did do an extraction on that, and they tied it to Mr. Blue, but, you know, the way people use cell phones nowadays, you have multiple people on your plan, and people share phones, and it's a piece of evidence. I don't think it's conclusive that it was Mr. Blue. Maybe Mr. Barclay had the phone in the back of the car. I mean, we don't know. But it's a piece of a bigger puzzle. Obviously, something the jury could consider.
Doesn't the defense attorney have an obligation when there's DNA evidence to be tested and they think it's fruitful to ask for an expert and have it tested themselves? I mean, the actual evidence is there, it's collected.
Yeah, I don't think defense counsel, trial counsel requested that to be tested, but the testimony at the trial basically was, well, 3 things. One, they don't do gunshot residue tests anymore, and in this case, they had sent tear gas into a house. I kind of say, okay, I see why you didn't do the gunshot residue. But the reasons given by the detective at the trial were basically, we can only submit so many pieces of evidence to BCI as a cost analysis, and then they were saying, oh, it's common areas of the vehicle, we probably would have got a multiple mixture of DNA, which wouldn't have been lead to admissible evidence or enough sufficient evidence to tie Mr. Blue to the crime, where, again, it could have been Mr. Barclay's DNA all over the inside of that car. And as I indicated earlier, Mr. Barclay left the scene and wasn't very cooperative from what I could tell from reading the record.
But does it really matter in the respect that if this is a complicity?
Well, I think that was one of the assignment of errors I threw in under the ineffective assistance of counsel, that they should have objected to that complicity charge or instruction that was given to the jury. I thought about arguing that a little deeper, but they didn't, it's an assignment of error for ineffective assistance of counsel. I understand he could be convicted under that instruction. If that was the case, then I have to point the finger back at trial counsel and say they should have objected to that instruction, because...
And counsel, I just want to let you know you're moving into your rebuttal time.
Okay.
You can continue if you'd like, but since you do.
No, I'll reserve the rest of it.
Okay,
Thank
very
you.
well, thank you.
May it please the court, Kevin DiMartino on behalf of the state of Ohio, the appellee in this case. We are asking that this court affirm Mr. Blue's convictions for murder, felonious assault, and tampering with evidence, because those convictions are supported by the sufficiency of the evidence as well as the weight of the evidence, and Mr. Blue was represented by effective assistance of counsel at the trial court. The crux of the defendant's appellant's argument is basically that the state failed to show that the shooter was Mr. Blue and/or that Mr. Blue was present at the time of the shooting. But when you look at the evidence in the record, it is clear when you look at the circumstantial and direct evidence that Mr. Blue was involved and that he was the shooter. Defense counsel acknowledges that circumstantial and direct evidence have equal weight, so I won't belabor that point. But the first piece of evidence is, how did this 19-year-old victim come to be at the location of the shooting, which the cell phone, which was found in the back of the vehicle, and the decedent was shot in the back in the vehicle, this all occurred on Bernice. The text message that came from Mr. Blue to the victim established the location, which was 1417 Bernice. And that address is significant because that property abuts the residence where Mr. Blue lives at 950 Russell. The surveillance footage that was introduced from Bernice shows the back of the property, which contains the cut-through, because that homeowner was having a lot of issues with people using the cut-through. So that's why there's not surveillance footage of the front of the house, which could have potentially shown the incident, because the camera was directed towards that cut-through, which the record further shows that now there's a fence there to prevent this type of thing from happening. So that's why the victim was there in the first place, because the defendant gave him that address and that's where he went. Their surveillance footage was about 45 minutes before the shooting. It shows two individuals, SB, who opposing counsel mentioned, as well as Mr. Blue. Also clear on that surveillance footage is the fact that the person who had the gun was Mr. Blue and not SB. The text messages, again, the phone was recovered in the back of the vehicle where the police believe the shooting occurred. That showed that within the same minute, so at 4:29, the victim said, "I'm here," and the defendant said, "Okay." Within 4 minutes of that text message, the victim is on the phone with 911, desperately trying to get life-saving measures, which did not come. The 911 call lasts until he becomes unresponsive. He attempts to drive his vehicle on Bernice. He crashes into a street pole and into a fire hydrant, and that's where the police find him unconscious, unresponsive at that time. So the overwhelming evidence, whether it's circumstantial or direct or both together, places the defendant and the victim within 4 minutes of that 911 call in the same location. And that location was on Bernice. The fact that SB was also there based on the GPS has really no bearing on whether or not SB was there as a means of saying that it's exculpatory. In fact, it actually helps us to place Mr. Blue there because Mr. Blue and SB were together that 45 minutes before when they came from Mr. Blue's house to the location where the shooting occurred. With regard to the DNA, on page 432 of the record, the forensic expert said that there was a swab of the trigger and the trigger guard. Again, that Glock was found in Mr. Blue's residence. He did not willingly come out, which is an indication of consciousness of guilt. They had to get SWAT there. They had to deploy tear gas. When they were able to get in there the next day, they found that Glock. The forensic scientist testified the swab of the trigger and the trigger guard. There was one major contributor, meaning one person who contributed more DNA than the other. That major profile was consistent with Christopher Blue. So the DNA does show his DNA on the trigger and the trigger guard, not just anywhere on the gun. So when you add all of those things together, the consciousness of guilt, the Glock that was found in his residence, the fact that he wouldn't come out, the fact that the shooter's cell phone was found in the back of the vehicle where the decedent died and had been shot in the back, and that cell phone is listed to YVB Chris Ford iCloud. Christopher Blue, the defendant, was a member of the Young Valley Boys, which is the YVB. When you add all of that together, within 1 minute they're at the same location. Within 4 minutes, this victim is deceased. The record contains ample evidence that supports the finding of guilt for murder, felonious assault, and tampering with evidence. With regard to the ineffective assistance claim, the state would argue that Christopher Blue was, in fact, represented by competent counsel. There's nothing in the record to support the allegations of ineffective assistance that are raised in the record. Whether Mr. Blue was the actual shooter or he was an accomplice and there was a finding of complicity, he was there. He was the person who had the gun. We were entitled to have an instruction. It would not have been error to allow it. With regard to the alibi claim that he asserts, there's nothing in the record to show that he ever filed a notice of alibi, which is required by the criminal rules to be filed within 30 days of trial. There's nothing in the record to support that he had an alibi. Therefore, trial counsel cannot be said to have been ineffective for failing to raise that. With regard to the cumulative error argument, the state would argue that there were no errors in this case, certainly none that were cumulative, and that would require a reversal of this case. If there are no questions from the court, I would rest on my brief. Thank you.
Thank you, counsel.
Thank you. On page 10 of my brief, I summarized the BCI expert testimony. In the middle of the page there, I have that Ms. Altzer testified that there were at least 2 DNA profiles on the gun, parentheses, item 2.1, indicating that at least 2 individuals handled that firearm. Ms. Altzer further testified that she could not distinguish who did what with the subject gun by her analysis or how the DNA got on the gun. In addition, she testified she could not determine whether Mr. Blue's DNA profile discovered on the gun was on the trigger or the trigger guard. So I think there is, since it was wrapped in the clothing for 20 hours and there's possibility of transfer, that's, I guess, a weight of the evidence type analysis. But the rest of what the prosecutor or the appellate attorney argued about whether it was direct or circumstantial evidence, I think when you look at the totality of the case, the vast majority of the evidence is circumstantial in this case. You have maybe Mr. Blue's cell phone in a car, and maybe his DNA is on a gun that's found. There was no testimony that the gun that was depicted in the video was in fact the same gun that was later found in the residence, and I guess they did a operability test and they matched up the shell casing, so I guess we do know that the gun that was found in the residence was the gun that was used to shoot the victim with, but there was no evidence presented that that gun was the gun that Mr. Blue possessed 45 minutes or closer to an hour before the shooting. I just, in closing, I would just say, again, you have a whole lot of circumstantial evidence here. Nobody puts Mr. Blue in sees him with the victim, sees him shoot him, sees him flee the scene. There's no testimony, yet they used a videotape to show him in the general vicinity of the shooting 45 minutes before, but they don't introduce any video that shows him at the scene at the time of the shooting, which was puzzling to me when I was reviewing the transcript. But I think there's a lot of evidentiary contradictions that can't be resolved to overcome reasonable doubt in this case, and I have to make the argument on behalf of my client that the jury lost its way, and that this is an exceptional case that the court should consider remanding back to the trial court and reversing the finding.
Counsel, I just have one question. I know you just raised the issue in regard to, in fact, this is the counsel with the complicity charge, but how would you be prejudiced? How would your client be prejudiced anyway?
With a complicity? Well, complicity, aiding and abetting, sometimes they have nuances to them, but yet they basically mean the same thing. It's, I guess, the same analysis where you drive to a bank robbery and you sit in a car and somebody shoots, so you're complicit in the murder.
Well, I guess my whole point is, if we find that there was no problem with the complicity charge, then whether he actually was the actual shooter or not is really irrelevant.
Well, I guess my response to that would be, there's still no evidence that puts him at the scene at the time of the shooting. Now, everybody's assuming, I guess, that this is a marijuana drug deal, but I don't recall on the record whether they found any marijuana in the vehicle on the side of the road or at my client's, or I don't think it was my client's house, but it's a 750 Russell Avenue. There's a big assumption being made that this was a drug deal and whether it involved one or two people. The state pretty much proceeded at trial, as I recall, that there was, I think that's what defense counsel's argument was. They proceeded at trial under the theory that Mr. Blue and only Mr. Blue was the shooter in this case. And then after all the evidence came out, that's when the complicity charge came. And, when you're a trial counsel and you're trying these cases, you want to say, whoa, wait. You never made that argument anywhere during the trial that Mr. Blue was not a shooter but an accessory and aided abetting presumably Mr. Barclay, the person who we know for sure based on his GPS monitoring device was at the scene of the crime at the time the shooting occurred. So it's the best I can do. All right, thank you.
Thank you, counsel. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day that it is released, and the opinions will also be posted on the Ohio Supreme Court website. Thank you both.